Argument in the matter of Gard Marine and Energy Limited versus China National Chartering Company Limited and others.
Lord Clerk will give the judgment to the court.
This appeal arises out of the grounding and subsequent loss of a vessel called Ocean Victory in a Japanese port called Kashima on the 24th of October 2006. In the appeal, the Supreme Court considered three questions. The first was whether there was a breach of the Safe Port undertaking in identical terms in three charter parties, namely a Demise Charter Party and two time charter parties. The claimant is Gard, which was one of the vessel's hull insurers. It took assignments of the rights of the owners under the Demise Charterers in respect of the grounding and total loss. It brought a claim against one of the time charterers, called Sinochart, for damages for breach of the charterer's undertaking to trade only between safe ports. Sinochart passed the claim on to Daiichi, who had subchartered the vessel from Sinochart. All the charter parties contained the same safe port undertaking. It was common ground that the question was whether the port of Kashima was prospectively unsafe when the charterers gave orders for her to proceed to discharge there. It was also common ground that the port was not unsafe if any damage was caused to the vessel by reason of, quote, an abnormal occurrence. In September 2006, Daiichi gave the vessel instructions to load at Saldanha Bay in south of Africa and discharge at the port of Kashima in Japan. The quay at Kashima was vulnerable to long waves, which can result in a vessel being required to leave the port. The only route in and out of Kashima is by a narrow channel, the Kashima Fairway, which is vulnerable to northerly gales. There's no meteorological reason why these two events should occur at the same time. However, on the 24th of October 2006, the vessel sought to leave the port due to what are known as long waves, but because of a severe northerly gale, was unable safely to navigate the fairway and was grounded, becoming a total loss. In the High Court, Mr. Justice Tier, the judge, held that there had been a breach of the Safe Port undertaking. The combination of the two weather conditions was not an abnormal occurrence, even though the coincidence of the conditions was rare, because both conditions were physical characteristics of the port. The Court of Appeal, comprising Lord Justice Longmore, Lady Justice Gloucester, and Lord Justice Underhill, allowed Daiichi's appeal on this issue. The Supreme Court unanimously dismisses the appeal on the ground that there was no breach of the Safe Port undertaking. I give the lead judgment, with which all the other justices agree, essentially for these reasons. It was common ground that the test for breach of the Safe Port undertaking is whether the damage sustained by the vessel was caused by an abnormal occurrence, that the date for judging the breach of the Safe Port promise is the date of nomination of the port, and the promise is a prediction about the safety of the port when the ship arrives in the future. The expression abnormal occurrence should be given its ordinary meaning, something rare and unexpected that the notional charterer would not have in mind. The test is not whether the events which had caused the loss were reasonably foreseeable. The fact that the combination of long waves and northerly gales was theoretically foreseeable does not make it a normal characteristic of the port. Regard must be had to the reality of the situation in the context of all the evidence to ascertain whether the particular event was sufficiently likely to occur to have become an attribute of the port. The judge erred in failing to answer the unitary question of whether the simultaneous coincidence of the long waves and gales was an abnormal occurrence. No vessel in the port's history had risked damage in the port due to long waves. At the same time, in the Kashima Fairway, was unnavigable because of gale force winds. There was also evidence regarding the exceptional nature of the rapid development, duration, and severity of the storm. On the basis of this evidence, the conditions in question were an abnormal occurrence, and there was therefore no breach by Daiichi of the Safe Port undertaking. The Supreme Court then considers issues 2 and 3 on the assumption that, contrary to its view, the charterers were in breach of the Safe Port undertaking. Under issue 2, Gard claimed to be able to recover the insured value of the vessel from the time charterers as the Demise Charterers assignee on the basis that the Demise Charterer is liable to the owners for breach of its safe port undertaking and is therefore entitled to recover the same sum from the time charterer. The Court of Appeal held that due to the joint insurance provisions, the owners were not entitled to claim against the Demise Charterer in respect of insured losses, reversing the judge's finding on this issue. Gard appealed to this court. Lord Toulson, Lord Mance and Lord Hodge conclude that the provisions of Clause 12 of the Demise Charter, which provide for joint insurance and a distribution of insurance proceeds, preclude such a claim. It is well established that co-insureds cannot claim against each other in respect of an insured loss. Clause 12 provides a comprehensive scheme for an insurance-funded result in the event of loss of the vessel by marine risks. The safe port undertaking does not alter this scheme. Lord Sumption agrees that co-insureds cannot claim against each other in respect of an insured loss, whether this is because liability to pay damages is excluded by the terms of the contract or because, as between the co-insureds, the insurer's payment makes good any loss and satisfies any liability to pay damages, will depend on the terms of the contract. In this case, Clause 12 of the Demise Charter envisages the latter. I agree with Lord Sumption on this issue, but we are in a minority. Under Issue 3, the Supreme Court considers whether Daiichi would be entitled to limit its liability for loss of the ship pursuant to the 1976 Convention on Limitation of Liability for Maritime Claims, the Convention, enacted into English law by the Merchant Shipping Act 1995. This issue was not considered by the courts below because it was accepted that they were bound by the decision of the Court of Appeal in a case called the CMA Jakarta, decided in 2004, which had held that such limitation was not possible. Accordingly, Issue 3 raises the question whether the decision of the Court of Appeal in the CMA Jakarta was rightly decided. In a judgment which I prepared and with which the other members of the Supreme Court agree, if there had been a breach of the safe port undertaking, Daiichi would not have been entitled to limit its liability under the Convention. Article 2.1a of the Convention allows owners or charterers to limit liability for loss or damage to property, quote, occurring on board the ship, or, quote, in direct connection with the operation of the ship. However, the Court agrees with the Court of Appeal in the CMA Jakarta that, giving the words their ordinary meaning, this category of claim to limit does not include loss or damage to the ship herself. This interpretation is supported by Articles 9 to 11 of the Convention, and there is nothing in the Travaux Préparatoires which supports another conclusion.